Hi, I'm Northern Virginia criminal defense attorney Scott Nolan, and I'm going to talk to you about preliminary hearings. What are they? When do you have them? What's the purpose? Well, first of all, a preliminary hearing is a thing that only happens for felony charges. If you have only misdemeanor charges or only traffic charges, you don't need to worry about preliminary hearings. After you've been arrested, the next day or so, you will be arraigned. That is, you'll be charged. Nothing else happens at the arraignment but charging and setting a court date. That court date, if you have felony charges, will be a preliminary hearing. All jurisdictions in the United States have some system of discovery, and Virginia's is by far the worst. We do not exchange police reports. We exchange very little information. Basically, we get to see videos and pictures, but nothing else. No witness statements, nothing else from the prosecution. What we have instead is a system of preliminary hearings where we get to listen as the prosecutor presents the information to the judge of the lower court in order to convince them to have a trial before a judge of the higher court. As a result, this is often the first time we hear evidence that might be convincing, or that it's the first time we hear the evidence. Now, earlier in the day, before the actual preliminary hearing, your lawyer has probably discussed the evidence with the prosecutor for the first time, as the prosecutor attempts to convince the lawyer that you need to make a deal. And maybe you do. In fact, most criminal cases are resolved just before the preliminary hearing, when the lawyer sees the evidence and says, yeah, okay, that's good evidence, let's make a deal. And it never then proceeds to the preliminary hearing. So I'm going to talk about those minority of cases where either you have not agreed to take a deal or the lawyer is convinced that you shouldn't. And at that point, you're going to proceed on to a preliminary hearing. The most important thing to know about a preliminary hearing is that it looks and sounds a lot like a trial. If you're not used to it, you're going to see a judge, a bailiff, a prosecution, witnesses. It looks very much like a trial, and you're going to wonder, what is happening? Is this my trial? It's not. The prosecutor is going to put on some witnesses, not necessarily all of them that will be at a trial, but some witnesses, enough to convince a judge that there is enough evidence to have a trial, and that's it. Your lawyer may cross-examine the witnesses. They may choose not to in some cases, but in most cases, your lawyer is going to cross-examine or question the prosecution's evidence. The only purpose for this is not to prove that you're not guilty. The only purpose is to elicit more information. Your lawyer is trying to get at the critical information that they're going to need to defend you at the real trial. The other thing we sometimes try to do is to nail down the answers that the witnesses are going to use so that they cannot later change them. Get the specific times and places so that the witnesses who sometimes do change their evidence can't do so. The second critical thing to understand is that your side of the story will not be told at the preliminary hearing. It is extremely rare that a defense attorney will provide any defense evidence, any defense argument at a preliminary hearing. The only arguments are the prosecutor did not provide enough evidence, judge, for you to certify this to the court. So given that the ending is almost a foregone conclusion, what should you expect to get out of this? Well, you should be able to sit down with your attorney after the preliminary hearing and say, what did we learn? What do we know now that we didn't know at the start? Now, the answer may be nothing. We knew all of that. Maybe. But most of the time, your lawyer is going to be able to say, well, we didn't know she was going to say this fact. Or it may be, that officer sounded a little shaky. Or, hey, did you notice he said it happened at 3:15 when we've been believing all of this happened at 3:45? Sometimes these details are critical, sometimes they're not. But your lawyer should have a much better chance to understand what kind of case you have after the preliminary hearing than before. So that's the day at which you should begin to ask your lawyer, how is this going to go? What do you think our best bets for a defense are? The last thing to know about preliminary hearings is that this is another time when the judge can reconsider bond, that is bail. The judge may decide, hey, based on what I just heard, I'm revoking your bond and you're going to jail. So be aware, that's at least a possibility. Doesn't happen all that often, but it could. Other times the judge might say, you had 2 charges, I only decided to certify 1, so that's an opportunity to reduce your bail. I had a case just yesterday where a man had 2 charges for a total of $25,000 bond or bail, and the judge only certified 1. So even before I had a chance to ask him, he reduced the amount of bail by half to $12,500. So that could happen. That's another chance for you to have your bond and bail reviewed. If you have any questions about preliminary hearings or any other aspect of the law, give me a call. I'd be happy to talk to you. And you have a great day.